Well, good morning. My name is Leonard Leo, and I serve as Executive Vice President of the Federalist Society. On behalf of the directors and management and staff of the Society, it's my privilege to welcome all of you to our 2012 annual convention, which marks the organization's 30th anniversary. Now, as many of you know, the Federalist Society had its origins after a small band of law students from Yale, the University of Chicago, and Harvard decided to establish an institution that could be a counterpoise to the liberal orthodoxy that permeated the legal academy and the legal culture generally. I do not think anyone really imagined that the organization would boast the size and reach that it has today. Chapters at every accredited law school in the country, along with 70 lawyers groups and 15 practice groups that put on about 1,500 events per year, dozens and dozens of experts and commentators who we facilitate to generate media and press reaching hundreds and millions of readers, viewers, and listeners with an estimated publicity value of tens of millions of dollars each year. A community of over 50,000 involved in the organization in various ways and degrees, a substantial number of whom choose to be citizen lawyers by taking up service in government or in the judiciary, by becoming active in pro bono litigation or public policy activity, by teaching, or simply by helping to generate this institution's important educational products. One book already has been written chronicling the Society's rise, and I have heard that there is a second, even more comprehensive book to be published about us next year by Vanderbilt University Press titled The Federalist Society: How Conservatives Took the Law Back from Liberals. I am not sure it is accurate to say that in what we have done, we take the law back from liberals and return it to conservatives. Our objective is to take the law back to what it should be, a means by which individuals and businesses can govern their own affairs, the centerpiece of which is a system of limited constitutional government forged by the Founding Fathers 250 years ago. We lawyers have been meeting each year in this room at the Mayflower going all the way back to 1987, I believe, although we do talk about people who met going all the way back to 1787, directing our attention to various aspects of our nation's project of limited constitutional government. During some of those years, we turned attention to particular areas such as foreign affairs, economic freedom, or the criminal law. In other years, we featured cultural themes such as personal responsibility or equality. And at times, we have directed our agenda to very specific constitutional architecture, such as federalism, the separation of powers, and the enterprise of judging. Whatever the particular emphasis, we seem always to arrive at a fundamental issue, and that is the way in which the structural features of our Constitution and the form of government that the Constitution has established stand as a bulwark for freedom and the rule of law and against tyranny. This has become our signature, and I believe the unique contribution we have made to discourse about the law and the Constitution in this country. This year will be no exception, placing a special emphasis on the future of U.S. constitutional law in the Supreme Court. We will explore the evergreen issues of limited enumerated powers, the separation of powers, federalism, and the role of the judiciary in policing these and other aspects of the structural Constitution. And this evening, of course, we will take some time off to don our tuxedos and gowns to come together to celebrate the Federalist Society's 30th anniversary. And celebrate we should, because though there is much work to be done and always many challenges ahead, this country has been better off with all of you Federalists coming together to find ways to serve our country at the forefront of its crucial constitutional and legal policy debates. And if we want our country to continue to strive with all its might to remain exceptional, it will require a motivated and refreshed community like this one to keep the flame of limited constitutional government burning brightly. And so we begin this year's gathering for debate, examination, fellowship, and intellectual renewal. And I am happy to welcome and turn the proceedings over to the moderator for our first panel on federalism and federal power, Seventh Circuit U.S. Court of Appeals Judge Diane Sykes. Thank you very much.
And good morning, everyone. I'm delighted to be with you this morning, and we begin this year's conference, appropriately enough, with a discussion of federalism and the limits of federal power in light of the Supreme Court's historic decision this past June in the healthcare cases. We have a truly extraordinary panel here this morning to help us interpret that decision, explain how we got here and what the court's decision portends for the future, and to offer some thoughts on the role of the courts in enforcing the boundaries of federalism. I will dispense with the long introductions. Most of our panelists are well known to this group, and their credentials are in your materials. But I have just a few words by way of introduction about each of our speakers, and then we'll get started. Leading off our discussion is Professor Randy Barnett, on my right, your left, the Carmack Waterhouse Professor of Legal Theory at Georgetown University Law Center. Professor Barnett is an influential legal scholar of long acquaintance with both the Federalist Society and the constitutional challenge to the healthcare law. Indeed, he is sometimes referred to in the press as the intellectual godfather of the Commerce Clause argument against the individual mandate, for his role in leading the development of the doctrinal and philosophical bases for the challenge. As practically everybody in this room knows, Professor Barnett is a passionate defender of liberty, a prolific writer, and the author, most notably, of the important book, Restoring the Lost Constitution, The Presumption of Liberty. Following Professor Barnett is Frank Easterbrook, Chief Judge of the United States Court of Appeals for the Seventh Circuit, my Chief Judge. I can say without exaggeration that Chief Judge Easterbrook is an absolutely brilliant legal thinker. In fact, our late colleague Terry Evans was fond of saying that Frank Easterbrook is so brilliant that the guy must have 5,000 cases in cold storage in his brain. But Frank's vast legal knowledge tells only part of the story. He is one of the most admired and influential judicial writers of our time. His opinions for the court are noted for their analytical power, explanatory force, and great eloquence. By the way, none of this will have any effect on my case assignments. Frank is scrupulously fair about that sort of thing. It just has the simple virtue of being true. Before joining the Seventh Circuit in 1984, Judge Easterbrook was a professor at the University of Chicago Law School. And before that, he served as Deputy Solicitor General of the United States. Next up is Neil Kitchell, partner at Hogan Lovells and former acting Solicitor General of the United States and principal Deputy Solicitor General. In his capacity as Deputy and then acting Solicitor General, and also as a private lawyer, he has argued 15 cases in the U.S. Supreme Court and many others in the federal courts of appeals, including the government's case in defense of the healthcare law. Before his service in the government, he was professor of law at Georgetown University and I think still teaches? And director of its Center for National Security in the Law. Neil is widely respected as a legal scholar and appellate litigator and is one to watch in the elite upper echelon of the Supreme Court bar. Following Neil will be Rob Nadelson, the senior fellow in constitutional jurisprudence at the Independence Institute and former professor of law at the University of Montana. He has written widely on a vast array of issues in constitutional law, mostly from an originalist perspective. I had not met him before today, but as far as I can tell, in addition to his work as a scholar and teacher, he has also been an entrepreneur and something of a political provocateur, having worked in journalism, hosted a radio talk show, spearheaded various referenda and legislative initiatives, and run for governor of the state of Montana. Next, we'll hear from Professor Heather Gerken, and I think we're a little out of order on the podium here, but that's all right. Professor Gerken is a rising star in the legal academy who is also no stranger to political action. Professor Gerken is the J. Skelly Wright Professor of Law at Yale Law School, where she specializes in constitutional law, election law, and civil procedure. She is a gifted and charismatic teacher and creative legal scholar. Among other projects, Professor Gerken is articulating a new and progressive vision of federalism that seeks to empower a wide array of Americans, especially national minorities, by emphasizing the role and influence of state and local decision-making bodies. Finally, we'll hear from Paul Clement, partner at the Bancroft Law Firm here in Washington, D.C. Mr. Clement served with great distinction as Solicitor General of the United States from 2005 until 2008. Before that, he was acting Solicitor General and Principal Deputy Solicitor General for 4 years, making his continuous years of service in that office the longest since the 19th century. In that role and as a private lawyer, Paul Clement has argued an astonishing 60 cases in the U.S. Supreme Court, including the challenge to the healthcare law and many of the court's most important cases in recent memory. He is widely regarded as one of the finest Supreme Court advocates of our time. Now I will invoke a little home state bragging rights. You may not know that Paul Clement is a native of Cedarburg, Wisconsin, coincidentally just a few miles up the road from where I grew up. Back home in our legal community, we like to claim him as Wisconsin's gift to the Supreme Court bar. And with that, I'll turn it over to Professor Barnett.
Well, thank you, Judge Sykes, and thanks to the Federalist Society. This is quite an intimidating panel to be on, and it's always an impressive audience to appear before. In 2005, in September 2005, the Wall Street Journal asked if I would write a tribute to Chief Justice Rehnquist, who had just passed away. I thought it would be fitting today, in talking about the future of the Supreme Court and the Constitution, as well as what happened in the healthcare case, to quote a little bit from the beginning and the ending of that piece that I did. Here's how it begins. Today we mourn the death of William Rehnquist. One day soon we may mourn the death of his legacy, the jurisprudence of the Rehnquist Court. And here's part of how it ends. As the new Chief Justice, assuming he is confirmed, will John Roberts assume the role of his mentor, William Rehnquist, for whom he clerked, and lead the Roberts Court to enforce the Constitution's original plan of limited federal power? A judicial withdrawal from enforcing the original limits on the powers of Congress would undo the new federalism legacy of William Rehnquist. As the president now decides who next to nominate, and this is what became the Alito nomination, he would uphold the Constitution by selecting a person with a firm and demonstrated commitment to the Rehnquist Court's new federalism legacy. Only such a choice would continue the movement to restore the first principles of constitutionally limited government that William Rehnquist affirmed so eloquently. One can hardly imagine a sadder end to the tenure of William Rehnquist than that his most prized and important contribution to constitutional law is aborted by a conservative Republican president and a Republican-controlled Senate. So here we are 8 years later, and where do we stand? Well, after the healthcare case, it turns out there is good news and there is bad news. So I'm here in my remaining 7 minutes to talk about why the good news came out the way it did, and to some extent why the bad news came out the way it did. First, the good news, and that has to do with the fact that we achieved 5 votes to affirm the proposition that the Constitution provides limited and enumerated powers, and that the courts will enforce those powers. And to understand why this was such an accomplishment, you have to understand that there isn't just 2 versions of federalism. There really are 3 versions of federalism, and it's the failure to recognize there are 3 out there that has explained why it is, for example, that most of my academic colleagues predicted that we would have no chance to prevail on these issues. The first version of federalism is the pre-New Deal version, which says that we are a government of limited and enumerated powers, that those powers should be interpreted according to their original meaning, and that much of what the federal government was trying to do before the New Deal and during the New Deal was unconstitutional. Obviously, we all know that this particular vision of federalism was supplanted by what we might call the New Deal vision of federalism. The New Deal vision of federalism has been interpreted by progressives, I think quite beyond what the court actually said, as basically repudiating the idea that there are limited and enumerated powers that are in the Constitution to be enforced by the courts, and essentially say that Congress has the power, the plenary power, to legislate as it will with respect to the national economy. Anything that pertains to the national economy is something Congress, in its discretion, may legislate. It's because most law professors held that view, and still hold that view, that when the Rehnquist Court established the new federalism, it came as quite a shock to them. because the new federalism established the proposition that there were limits, what Chief Justice Rehnquist referred to as first principles of constitutional government, and that these limits would be enforced by the court, something that seemed to reject and repudiate the New Deal constitutionalism. And it did, to the extent that I've just described it. But the question that then arises is, did it go all the way back to the pre-New Deal federalism? And I want to suggest that it did not. What it did do, but it was the thought that it did assert the privilege, the theory of the pre-New Deal federalism that got everybody so worried amongst my academic colleagues, and who, once the Raich case was decided in 2005, thought, aha, now that the Rehnquist Court is no longer going to enforce the limits of the Constitution, we are back to where we started, which was that New Deal understanding that Congress can do whatever it wants as long as it's affecting the national economy. But I don't think that's the appropriate interpretation of what the Raich case did, and I don't think it's the appropriate interpretation of what the Rehnquist Court was for. The Rehnquist Court, the new federalism of the Rehnquist Court, was a genuinely new federalism. It was not a return to the pre-New Deal federalism. In my view, that's unfortunate, but that was what was possible. What the new federalism represents is something that we might call this far and no farther. Now, it's not literally this far and no farther, because this far and no farther would mean, well, anything that the federal government, any power that the federal government has claimed up till now it can have, and any new power it cannot have. That's not exactly, I think, what the Supreme Court has done under the new federalism. But what it has done is this. It says everything that the Supreme Court, everything that Congress tried to do under the New Deal Court is constitutional. We've accepted that. That's what we'll call what's sometimes called the New Deal settlement. But if the Congress wants to go beyond what it's done before, if it wants to do something new and what we might call unprecedented, then it bears a heavy burden of justification to explain why this is justified and why it doesn't lead to the conclusion that Congress does have an unlimited and plenary power or a police power over the national economy, which is a proposition that the Rehnquist Court rejected. And that is the intellectual milieu in which we brought the health care challenge. That is the court still going to hew to this far and no farther line, or has it really accepted the law professor's interpretation of the New Deal that gave Congress a plenary and unlimited power over the national economy? And I think what we discovered as a result of that litigation, and to the surprise and shock of many law professors, is that in fact the Rehnquist legacy of the new federalism is still alive, and in fact pretty well, insofar as it gathered 5 votes for the proposition that Congress's commerce power is limited, that the necessary and proper clause is not a carte blanche to get around the limits of the commerce clause, and that the courts were in a position to draw a line and say this far and no farther. And since the individual insurance mandate was unprecedented, literally unprecedented, the Congress and the executive branch was under a burden to justify why the rationale being offered on behalf of that was not going to lead to an unlimited federal power. Because they failed to meet that burden, they lost on that particular issue of the case. So that was a huge victory, and it has now put into there's no way that law professors can argue the same way about what the meaning of the Commerce Clause and the Necessary and Proper Clause is under the current Supreme Court doctrine that they did prior to our bringing our lawsuit. But as you all know, the outcome of the case was somewhat disappointing, actually considerably disappointing. I haven't quite gotten over it yet. And that is that the Obamacare, the Affordable Care Act, was generally upheld. And we all know why that happened. It happened because a 5th vote, there was not a 5th vote there to hold the line at the Commerce and Necessary and Proper Clause that there were 5 votes to identify. In other words, there were 5 votes to identify that there was a line there, but there were not 5 votes to hold that line. There were only 4 votes to hold that line. And the 5th vote decided to rewrite the text and to eliminate the mandatory or requirement part of the individual insurance mandate, deal only with the penalty, recharacterize the penalty, therefore, as a tax because it was of a limited character and it did not have a punitive character, and then uphold that provision as constitutional, having rewritten it. So I'm going to close these remarks by asking why this happened. How did this happen, and what does this mean? And to explain that, I think I have to make a distinction, one more distinction, and introduce that into this discussion. That's the distinction between what I'll call judicial conservatism and the position that I'll call constitutional conservatism. Judicial conservatism is the position that many in the Federalist Society and other conservatives have favored and advocated for many years, for as long as there's been a Federalist Society. And this is the position that that advocates the doctrine of judicial restraint. That is the idea that judges should defer to the popularly elected branches of government in deciding on the constitutionality of the scope of those governmental powers. There should be a judicial restraint or deference. The constitutional conservative alternative, which is one that I think I'm happy to say has a lot of popular valence these days, and that is that the entire Constitution is a limit on all three branches of the federal government, and that the judiciary is charged with enforcing those limits against the other two branches and should not shrink from that commitment, from that obligation, from that judicial duty. And we could call that, instead of the philosophy of judicial restraint, we could call that the philosophy of judicial engagement. So what did we learn from this particular lawsuit? I think what we learned from this lawsuit is, number one, this is something that Leonard Leo said immediately after it, and that is that 5 conservative justices are not enough. 5 votes are not enough. If you only have 5 votes, there's a very good likelihood if the pressure is turned up great enough that somebody's going to break, and you're not going to be able to hold all 5 votes. We had to run the table in this case. We had to get a unanimous vote of the only 5 votes that were willing to consider the fact that there were limits on the federal powers that we were seeking to enforce. We had to get a unanimous vote of the 5 justices who were actually listening to this part of the argument, and we failed to get a unanimous vote. So 5 votes are not enough. But here's the other lesson. I think it's a lesson for us to think about the next couple of days as we're debating these issues from a variety of perspectives. And that is whether we really ought to reconsider, or those who are committed to this really ought to reconsider this ironclad commitment to judicial restraint. Because isn't that really what we saw in this case? What we saw was 4 justices who were committed to the proposition that it was their responsibility to uphold the limits on the Constitution under the enumerated powers scheme. And as interpreted through this new federalism provision, philosophy of this far and no farther. And we had one justice who was not prepared to do that. We had one justice who looked for an out. We had one justice who looked to save the statute in order to defer to the popularly elected Congress and the very popular Affordable Care Act. That's the irony, of course. We deferred to an unpopular Congress and an unpopular act, but that's where we are. And I think we have to, going forward, I think we have to think about whether that is really the judicial philosophy that we want to adhere to in the future. Or instead, do we want to pick justices who not only profess a belief in the principles of federalism that we believe in and the principles of limited and enumerated powers, but also have the character and the fortitude to stand up to what in this case turned out to be withering public pressure in order to enforce those principles. We saw what it looks like when 4 justices would do that. We saw what it looks like when justices will do that. Unfortunately, we lack the 5th vote to do that, and I think in the future we have to be prudent in who we favor to fill these roles. Otherwise, this legacy of William Rehnquist that I described upon his death will in fact expire, but it hasn't so far. And in fact, in some respects, we've moved the ball far forward than what it was upon his demise. Thank you.
The written précis for this panel concerns the Supreme Court's federalism decisions. I confess, however, that I'm more interested in the Constitution's federalism rules, which may or may not be the same as the court's. The original plan, sketched in Madison's Federalist No. 10, was to diminish the power of interest groups by diffusing power. Some power would be national, all residual powers would be held by the states, which would compete with one another. Groups able to dominate one state would fail elsewhere because economic interests would differ. Some states were agricultural, others specialized in manufactures and trade. The states could ensure their independence by controlling the Senate, for senators would be elected by states, not by the people. And the ability of factions to control the national government would be diminished not only by the state's choice of senators, but also by the different electoral bases of the House, 2 years from local elections, and the executive, indirect elections for 4 years. Representatives with different electoral bases would compete against one another, protecting the people. That structure of diffused powers, not any delegation to the Supreme Court, is the Constitution's formula for protecting liberty through federalism. The 1787 plan is less useful today than formerly, though, for several reasons. One is the 17th Amendment, which provides for the direct election of senators, cutting the states out of the process. Another is the 16th Amendment, which gives the national government an essentially unbounded taxing power. As Chief Justice Marshall said in McCulloch against Maryland, the power to tax is the power to destroy, and we can add today, the power to regulate. A third is the Supreme Court's conclusion in the early 20th century that the federal commerce power can be used as a conditioning power. That is to say, Congress can provide that nothing moves across borders unless it meets certain conditions. That was used to adopt child labor and minimum wage laws, and long before the New Deal. If a product is made by children, it can't be shipped across state lines. Congress might have regulated health care using the conditioning power. That power, plus taxation, makes judicially adopted limits of little value. The Supreme Court could overrule Wickard against Filburn tomorrow morning without establishing any limits on national power. A fourth reason why the Constitution's original structure of federalism has faded is the change in the economy. The assumption behind giving commerce power to the national government and residual power to the states is that few goods moved in interstate or international commerce. Most economic transactions were local, just as most people died within 50 miles of their birthplace. But canals, then roads, then railroads, trucks, air travel slowly decreased the cost of transportation, which increased the portion of the economy that crossed state and national borders. The telegraph, telephone, and internet reduced the cost of communication. Today, information is a global economy, and even a call to your next-door neighbor might be routed through a satellite 23,000 miles overhead controlled by an international authority. As the scope of interstate and international commerce grows, so does national power. That's part of the original plan. The Constitution gives the national government authority to regulate interstate and foreign commerce as it is in the world, not as it was in the contemplation of those living in 1787. It's not the function of the judiciary to turn back the clock. The goal is to implement the original public meaning, not the original anticipated consequences. Today, the national government is to commerce what states were 230 years ago, and cities are to commerce what states were in the long past. Now, having said that, I don't think that the change in the cost of transport and communication implies the wisdom of using whatever powers the national government possesses. Many of the other speakers will spend most of their time on health care, but I want to start elsewhere, looking to the domain of corporate organization and securities. Efficient finance is essential to economic productivity. Efficiency depends on the absence of fraud, but all 50 states, even Nevada, prohibit fraud. Efficiency also depends on competition and choice, for different organizational structures best suit different firms. And states compete for businesses, not just for corporate charters, but for limited liability companies, business trusts, partnerships, and so on. Federalism sets the stage for competition, which facilitates economic growth. There's a powerful tendency toward optimal legislation at the state level to the extent four conditions hold. People and resources are mobile, the number of jurisdictions is substantial, so you don't get monopoly power, jurisdictions can select any set of laws they desire, and all the consequences of one jurisdiction's laws are felt by people who live in or consent to that jurisdiction. In other words, no externalities. Competition among the states concerning corporate charters and other business organizations meets those conditions. Firms are mobile, they can change their place of incorporation even if they don't relocate their plants. Investors are even more mobile. They can invest in firms located anywhere, not just in the United States, but anywhere in the world. Until recently, the jurisdictions weren't significantly constrained in the choices they could offer. And finally, the effects of chartering are largely confined to the investors who choose their particular investment vehicles. There are few spillovers, and those spillovers are priced. Recently, though, the domain in which states may compete has shrunk. Congress has begun to enact laws controlling how firms must be organized, how boards are elected, who may be on the board, what committees it may have, and other details. The Sarbanes-Oxley Act, which Randy Barnett has never challenged, but which I think does every bit as much damage as the Affordable Care Act, is full of those rules. Ironically, given its genesis as a reaction to Enron and other scandals, the terms of this statute require every corporation that engages in interstate commerce to be governed just like Enron. Enron had a majority independent board, an independent compensation committee, and met every requirement of the Sarbanes-Oxley Act. The economic effect of Sarbanes-Oxley was very powerfully negative. When the national government specifies details of corporate organization, the competitive model of federalism falls apart, and we can get a real race for the bottom. I think that this reduction in federalism in that part of the economic sphere is much more significant for the long-run economy than the recent developments in healthcare. For federalism in healthcare was a lost cause long before the Affordable Care Act. Competition among the states in healthcare and healthcare payments is possible. Insurance policies could be regulated just like corporate charters, which is to say, by the issuing state. Insurers based in Wisconsin could offer different options from those offered by insurers based in Massachusetts or Arizona. Competition could easily occur. Congress set the stage for it in the McCarran-Ferguson Act, which provides that state law supersedes federal law on the topic of insurance unless federal law explicitly governs. But it turns out the states themselves blocked that competition. Most states insisted that their domestic law govern all insurance policies. Not just that Virginia law apply to all policies issued to Virginia residents, even if the issuer is located in Missouri, but also that the issuer get advance permission from Virginia regulators to sell the policy at all. So much for competition. The states also took the bait offered in Medicaid. In exchange for a subsidy, they agreed to let the national government set the rules of medical care, covering a large segment of the population. And having done that, the states not only canceled the benefits of federalism, but also gave people strong incentives not to carry insurance. Just as with disaster relief, not planning for the future is rewarded by a subsidy. When the states and Medicaid jointly took federalism out of the picture, the federal government moved in. And this is long before the Affordable Care Act. Think only of tax law and ERISA. Tax law gives a big advantage to health care provided as a fringe benefit of employment because the cost is excluded from taxable income. The tax rules affect what sort of benefits can be offered and thoroughly warp incentives in the private insurance market, and indeed whether to insure at all. ERISA regulated welfare benefit plans, and health insurance is a welfare benefit plan. So competition was constrained long before Obamacare. Moral: if states want federalism, they must respect the rules of competition. When, as with insurance, the states themselves defeat competition, they must expect the national government to take over. Thank you.
Thank you very much. I appreciate so much the invitation to be here. And before gently chiding what some of my colleagues on the panel have been doing for the last few years, I did want to offer a word of praise first to my dear colleague Randy Barnett, who was described as the intellectual godfather of the healthcare challenge. He's also really the guy who's making law professors relevant again to the real world, and I think it's a really wonderful example that he's set for us in the legal academy. And then a word about my dear friend Paul Clement over there, who was described by Judge Sykes as one of the finest Supreme Court advocates. I actually think he's the finest Supreme Court advocate practicing today. And anyone who didn't hear those 3 days of the healthcare argument and listen to Paul, I have not heard a more marvelous set of arguments in my life, and it was really quite a spectacular thing to see. The timing of this convention is auspicious. I suspect my week last week was a bit better than yours. And I didn't come here to gloat. I am here to actually say that you all should be happy. And at least if you're going to take Mr. Leo's statement that the Federalist Society stands for taking law back and returning government to the people, if that's taken seriously, I actually suggest that last week's election is actually good for those concepts. And the reason is not the Obama is better kind of thing, but actually it goes back to what Professor Barnett was saying a moment ago about how there are two essential strands in the Federalist Society. One is the strand that he calls judicial conservatism, the tradition of judicial restraint. The other he called constitutional conservatism, the idea that the third branch of government has to strictly enforce the Constitution. Now, when I was in law school, it seemed to me that the Federalist Society had won the first principle. And I think it deeply influenced my generation of people, the tradition of judicial restraint. You have unelected judges, and effectively, if there's constitutional doubt of whether a law is constitutional or not, you defer to the political processes. I thought that was what the Federalist Society stood for. I thought it was a deeply held, powerful belief, and it influenced, I think, my entire generation of law students, and then whatever we wound up doing afterwards. Now I see a total breakdown in that basic philosophy, and you see it even in Randy's eloquent work. I mean, if you read his book on the Ninth Amendment, which is marvelous, if you listen to Randy even today saying that the good news was that the Supreme Court struck down the Affordable Care Act on Commerce Clause grounds, an act that regulated 17% of the gross domestic product, you start to really wonder, what is the tradition of judicial restraint that's left? And indeed, when I read Randy's book, I don't think it's all that different than the last Carmack Waterhouse professor at Georgetown, Mark Tushnet. I do think that there's a deep similarity in the structure of the argument that the constitutional conservatives are making about the role of the judiciary in policing state and federal boundaries. And I do think that essentially there's a little bit of a lost set of bearings, and you see it really in the healthcare opinion. And the Chief Justice, and I think Paul is now the best advocate, in part because the Chief is not an advocate before the court. He was really a marvelous advocate, but you read the Chief's opinion and it doesn't actually, cohere all that well. And the first part of the Chief's opinion starts with what Randy talks about the idea that, well, there's no precedent for the healthcare legislation, therefore it's presumptively unconstitutional. This is what the Chief says. He says, quote, "Perhaps the most telling indication of the severe constitutional problem is the lack of historical precedent for this entity. Neither the majority opinion nor the United States has located any historical analogs for this novel structure." And so that's the step one. And then step two of the opinion is to say, oh, don't worry about that because I can rewrite the statute in a way to make it constitutional, a saving construction, which is the technique he had used 2 years before in Northwest Austin versus Holder, the Voting Rights Act, similarly to say we can rewrite the statute, the bailout provision, to make it constitutional. Now, these two concepts, these two moves are deeply problematic, it seems to me, on their own terms, and they're in tension with each other. The first one, this anti-novelty canon, the idea that something is presumptively unconstitutional simply because it hadn't been done before, is deeply in tension with McCulloch versus Maryland, our foundational Supreme Court opinion. It's certainly not anchored in the text, structure, or history of the Constitution. And I submit to you, it sounds very much like something called a penumbra that other justices were talking about in the 1960s. The other move which was made is this idea of rewriting rewriting a statute to save it from constitutional difficulty, which I think is at least as activist as striking something down in terms of the rewriting power, to write a statute that is literally never even been enacted before. I mean, that's what happened with the Voting Rights Act, the bailout provision. Literally nobody thought that the bailout provision meant what it said, but that's what we get. We get a similar type of structure of the argument with the healthcare case, and the result of it is that we've now had an opinion which blesses a statute which is so unprecedented that literally nobody's ever enacted it in American history. And that strikes me as really not the right place to be. Now, the criticism, I suspect, in all of these, whenever anyone talks about judicial restraint, is for the other side to say, oh, that's not being activist because that was clearly unconstitutional, and I just want to return to the tradition of constitutional restraints, and that's all I'm trying to do. And that's what the left said for 40 years when there were all sorts of decisions made by the Warren Court that they had to defend that struck down statutes, and now it's what conservatives are saying when you have victories in the U.S. Supreme Court that strike down legislation that you don't like. Activism seems to be whatever the last decision is, constitutional decision that you didn't like. And, you know, I think it's time now to really end that debate. And there is a solution. It's a solution that's been around since 1892. It's James Bradley Thayer's solution, which is that if something is not clearly unconstitutional, you defer to the political branches. And I understand we can disagree, Randy and I or others, about different things, the Affordable Care Act or any number of other pieces of legislation, but it seems to me that it's important to return to that idea about judicial restraint as an impulse, a disposition, a way of thinking about the role of a judge in our three-part system of government, which says they're the ones who are unelected. And because they're the ones that are unelected, we should be suspicious, and we should try and ensure that unless something is clearly unconstitutional, that they don't use it as a license to strike down legislation that they happen to disagree with. And so in that sense, there really is good news for you all from last week. We are right now behind the veil of ignorance. We don't know what the retirements will be on the Supreme Court. For the last 8 years, the political left, when it comes to judicial discussions, has sounded very much like the right and the old Robert Bork, and saying judicial restraint, judicial restraint, judicial restraint. And the conservatives had said something else. And you know, it's been essentially you know, about who's on the court, and that informs the judicial philosophy. Right now, we are behind the veil of ignorance. The left is talking about judicial restraint. The right has not been as much recently. And it seems to me this is the time for us to really think through, does an entity as august as this really want to embrace Randy's invitation for a constitutional conservatism? It strikes me as dangerous just in terms of just the kind of underlying issues, but more importantly, it's a step away from the really fundamental insight that you all had, which was judges should be restrained. There should be an impulse of restraint, and unless something's clearly unconstitutional, courts shouldn't be mucking around and declaring it unconstitutional. Thanks.
We were having a debate as to who went next. I also am not here to gloat, although I will point out that last Tuesday I was in the boiler room of what turned out to be a data-driven, highly organized, highly teched campaign with the CEO who knew how to run a highly disciplined campaign, and surprisingly enough, it was a Democrat. I was working in the Obama campaign last week, and I am thus, to quote Elena Kagan, "You are not my people." I am not a member of the Federalist Society, but I am a member of the Federalism tribe. Much of my work has been devoted to making the progressive case for federalism, even the nationalist case for federalism. I spent the last 5 or 6 years addressing the question that all progressives have about federalism, whether it harms racial minorities and dissenters, the true groups that we worry most about in a democracy. Progressives will not be convinced of federalism's merits without an answer to that question. But federalism's proponents typically offer little more than an apologetic sidebar on the race question, and they don't have all that much more to say on the dissent side, and I think that's a mistake. So my work has been devoted to showing that federalism and its homely cousin localism play a crucial role in promoting the political and economic integration of racial minorities and in generating dissent and democratic debate. I assume, however, my role here today is to provoke. So by way of provocation, I want to offer a friendly suggestion to those who believe, as I do, in federalism, who believe in the important role that states play in our democracy, And it's a suggestion that is directly related to the healthcare case and the brouhahas that preceded it and followed it. You are the lawyerly tribe that actually cares about state power. And I think you are thinking about it in the wrong way. Most of you are ignoring the most important source of state power in the 21st century, one that will only become more salient as time goes on. Now, most of you, I would guess, are deeply interested in the battle between the sovereigntists and the process federalists. And while that battle may not be over, it is coming perilously close to degenerating into the intellectual equivalent of the taste grace, less filling debate. Scholars on both sides of that debate have spent so much time worrying about whether it's state sovereignty or autonomy that matters, whether we need de jure judicial protections for state power or just de facto political protections for it, that they have missed a simple fact. Much of the state-federal power game has shifted to precisely where the healthcare bill takes us today, the realm of cooperative federalism. That's where the action is. That's where the future is. And if you care about state power, it might be useful to devote some of the massive intellectual energy now spent on the well-worn sovereignty process debate to thinking about how to ensure that states retain an important role in governance going forward. In my view, the part of Sibelius that matters in the long term isn't what we've all been talking about up on this panel so far, the Commerce Clause ruling. It's the Spending Clause ruling. That's the part of it that goes to the heart of how the states and federal government will interact going forward. And while nationalists call it cooperative federalism, may I suggest that those of you who care about state power might think about these institutional arrangements as opportunities for uncooperative federalism. Now, I understand all the attractions of the sovereignty model, but as a descriptive matter, sovereignty is rarely, if ever, to be had in our increasingly integrated national system, as Judge Easterbrook, I think, pointed out. You can try to set some limits on the Commerce Clause. You can forbid commandeering, but the federal government has too many paths for achieving its ends. If the national government wants to invade a regulatory sphere, the odds are that it will find a way to do it. The Rehnquist Revolution was an effort to hold back the tide, and recent events have reminded us just how hard it is to hold back the tide. And yet, states are powerful. They are powerful because they play crucial roles inside the federal system rather than outside of it. States matter. They matter quite a lot for environmental policy, for healthcare, for welfare, for Medicaid, for a vast array of policies that are highly salient to their citizens. Now, sovereignty types tend to dismiss cooperative federalism as a sport. They think it's not real federalism. It's not our federalism. To them, the power that states wield in cooperative federal regimes doesn't feel like real power, and therefore they think it cannot promote federalism's ends, that it does not allow states to play the crucial role they're supposed to play in a democracy, challenging national power and preventing national overreaching. But they are wrong about that. The role that states play in so-called cooperative federalism regimes gives them a great deal of power to interpret, influence, even resist federal mandates. As with the healthcare law, state officials regularly administer federal policy, often with politicians, governors, and state legislators serving nominally bureaucratic roles. As policymaking insiders, state officials can resist federal policy from within rather than challenge it from without. And they do. There are countless examples of state resistance and rebellion inside the federal administrative state. The term we use to describe these themes is cooperative federalism, but the truth is they can be and often are, in fact, uncooperative federalism. Now, constitutional scholars neglect uncooperative federalism, this important source of state power, because they mistakenly think that the only form of power is the power of the sovereign, the ability to preside over one's own empire. They thus miss how much power is wielded by the servant when state officials administer federal policy. And given how far the national empire now reaches, given how much of the regulatory game is now within Washington's ambit, it is all the more important to pay attention to the role that states play in administering federal law. Now, if you think that the power of the servant isn't a form of power at all, then maybe you should spend a little time talking to someone who does administrative law, or indeed anyone who has written on the principal-agent problem. There is a reason why so many fields are obsessed with the principal-agent problem. The agent is powerful despite his nominal status as servant. The power of the servant looks different than the power of the servant, but it matters. That's precisely why the phrase the principal agent problem is a term so common, it doesn't require explanation. In my view, the challenge for federalism's fans is to think about the productive possibilities associated with the principal agent problem, to identify the ways that the principal agent problem isn't a problem at all. And if anyone is ready to do that, it is the people who care about federalism. In their role as federal servants, state officials enjoy all the advantages of policymaking insiders, even as they enjoy another advantage that federal bureaucrats do not. State officials' constituency, their power base, lies outside the national system. They may be servants, but they are servants with two masters and thus answer to their own people. And it's little wonder then that we see such variation in the administration of federal law, even when it seems like there is no discretion to be had. We talk a lot about the power of street-level bureaucrats, the ability of even the cop on the beat or a low-level administrator to shape policy. But what we often forget is that the power of the street-level bureaucrat is not confined to the street. Now, I don't want to suggest that this form of power will seem entirely satisfactory to someone who believes that states should preside over their own empires. But it seems to me that that is not the relevant question this day. In this day and age, the real question is this: given how many areas where the national government now plays a substantial regulatory role, should the states want to be in the game or on the sidelines? Should state officials sometimes prefer to administer the burgeoning federal empire rather than preside over second-rate empires of their own? If you worry about the growth of the administrative state, shouldn't you be thinking creatively about the ways that states can play the same role inside federal administration as they now play outside of it? Now, you can say, of course, that the federal empire ought to be radically trimmed, and I will simply say, good luck with that. So how do we think of the new healthcare law? Thus far, it has been framed in utterly conventional terms as yet another national intrusion on state power, and that's certainly true of parts of it. But when the policy-making gods close a door, they sometimes open a window. And here the policy-making gods have guaranteed that state officials will play a crucial role in administering a crucial federal law. They will be able to provide a source of dissent and resistance and change for national policy that is going to matter a great deal to a great many people. Maybe some of them will do what the governors of Michigan and Wisconsin did when they used their power to administer federal welfare law to create competing systems that eventually helped lay the groundwork for welfare to work and toppled the national system. Maybe they'll do what some states did with the Patriot Act and others did with environmental regulation and simply refuse to implement federal law. Maybe they'll be so enthusiastic about the program's merits that they will prod the national government to do more, as California has rebelliously done on the environmental front. At the very least, they will have a chance to reproduce the same type of resistance and dissent and dialogue within the federal administrative state as now exists outside of it. And this brings me to Chief Justice Roberts' spending clause ruling, which outraged so many of my fellow liberals. I think of that portion of the opinion in more generous terms. I think of it as a first, admittedly rough effort to think about how to regulate the ongoing iterative relationship between the states and the federal government when they partner, to ensure that the principal can't pull the rug out from under the agent even when the agent rebels. It may not be the right way to think about cooperative and uncooperative federalism, but it is an effort to think about it, and for that reason I think it's worth applauding. Again, this may not be your ideal model of state power, but it is power, and it is worth thinking harder about. It is a mistake to cede this crucial regulatory terrain to the nationalists, who write only in the sunniest terms about the cooperative role that states play in these regimes. What we need is for people to think about the other equally important dimensions of federalism, those involving dissent and resistance. It is time to stop focusing on closed doors while ignoring open windows. It's time to pay attention to the power of the servant. It's time to think about the productive possibilities associated with the principal agent problem. It is in time, in short, that we recognize that cooperative federal regimes, like the new healthcare law, are not a sport. They're not non-federalism. They're actually opportunities for uncooperative federalism, which is every bit as much a part of our federalism as anything else that we will discuss today. Thank you.
Good morning. It's a real honor to be on this panel among some of my personal heroes, and it's a real honor to speak to you today. Two recent events should be sobering for those of us who are committed to the founder's vision of federalism, or, with deference to Professor Gerken, federalisms. The first was the Supreme Court's decision to uphold most of the Affordable Care Act. The second, of course, is the outcome of the recent election. Both demonstrate the basic failure of the strategy of trying to restore constitutional limits by concentrating exclusively on federal elections and Supreme Court appointments. The fact is that no Congress or president is likely to do much to restore constitutional limits on federal power, and any efforts of the Supreme Court will be marginal at best. I'd like to talk to you today about a better way of restoring federalism, one that more and more people are discussing at the state level, but really hasn't made its way back yet into the federal consciousness or the national consciousness. This is the ability of states, and particularly state legislatures, to amend the Constitution to rein in a runaway central government. Think back for a moment to the debates over the ratification of the Constitution during the period 1787 to 1790. Those who opposed the Constitution had a range of arguments, but two of those arguments were at the heart of their case. The first was that the Constitution granted too much power to the federal government, and that could lead to abuse. The second argument was more subtle, but ultimately it was more prescient. It was that even if the Constitution, when honestly, fairly, objectively read, did not give the federal government too much power, nevertheless, ambitious and clever people would twist its language to justify the central government seizing enormous power, even if that contradicted the understanding of those who wrote and ratified the instrument. To these arguments, the advocates of the Constitution responded in four ways. First, they emphasized the limited scope of the authority given the federal government. An example is Madison's famous statement that, quote, "the powers delegated by the proposed Constitution to the federal government are few and defined." This was not just campaign rhetoric, because when you examine the Constitution's power grants against the background of 18th century usage and 18th century jurisprudence, you can see that for the most part they were fairly well defined. The phrase regulate commerce, for example, was understood to mean governing activities such as mercantile trade, navigation, cargo insurance, and imposing certain tariffs. But, as Randy Barnett, I, and others have documented, did not include such activities as manufacturing, most insurance policies, or health care. Second, advocates of the Constitution listed explicitly activities the federal government could not regulate and that would remain within the exclusive jurisdiction of the states. These included local businesses, agriculture and other forms of land use, real estate titles and inheritance, local government, tort law, and other aspects of civil justice among people in the same state, criminal law, religion, education, and social services. The Constitution's advocates sold the document to the ratifying public precisely by representing that such activities were outside the federal sphere. Now, let's make one thing clear. Everyone understood that even then there were close interrelationships between these activities reserved to the states and the activities subject to federal regulation. But for overriding and very good reasons, certain matters were left out of federal jurisdiction. The third thing the Constitution's advocates did was, after some hesitation, they promised a Bill of Rights. And the fourth, the one most germane here, is they emphasized that Article 5 gave the states substantially unilateral power to adopt amendments, which the states could do if the federal government proved oppressive. In other words, the founders saw the amendment procedure as more than a way of responding to changed circumstances. They saw it as a tool for curbing excesses and abuses. During the ratification process, many of the Constitution's advocates pointed out that the states could not only ratify proposed amendments, but that acting through their instrumentality, something that the Constitution calls a convention for proposing amendments, they enjoyed concurrent power with Congress to propose changes in the instruments. That is why Alexander Hamilton said that if the states were determined to insert a corrective amendment into the Constitution, then, quote, that amendment must infallibly take place. Over the last 50 years, state lawmakers have largely overlooked their amendment power because of widespread misunderstanding about this convention for proposing amendments. It is commonly and inaccurately labeled a constitutional convention, and it is assumed to be inherently uncontrollable. Many seem to think it is independent of the state governments, that, for example, Congress can designate how delegates are chosen or how they're allotted. Such misconceptions are the product of ignorance of the relevant history and law. These misconceptions also, unfortunately, are promulgated by groups who are opposed to any amendments. In fact, the Convention for Proposing Amendments is nothing but a diplomatic gathering of the states, to which each state sends a delegation, called a committee, and in which each state stands in a position of sovereign equality. The convention's agenda and its deliberations are subject to the limits imposed by the state legislatures. This is clear from 18th century convention practice, from the record of the framing, from the debates over the Constitution's ratification, and from subsequent history and some subsequent case law. The founding generation had had extensive experience with interstate conventions. The convention that wrote the Constitution was only the latest in at least 18 gatherings among the states that occurred within the lifetime of Benjamin Franklin alone. Leading founders had attended many of these gatherings, and convention's procedures and protocols were well understood. We can recover them today in the convention journals, calls, and other records. When you examine these procedures and protocols, you understand why so many founders affirmed that the states could have any amendments they wanted. In an interstate convention, like the Constitution's Convention for Proposing Amendments, the states run the show. Congress has almost nothing to say about it beyond fixing the time and place in the call and identifying the subject matter specified by the states in their applications. Each state legislature fixes the number of delegates. Actually, the delegates are called commissioners from that state, and determines how the commissioners are selected. The state legislature or its designee grants and defines their authority, instructs them, and may recall them. Once gathered together, the convention adopts its own rules, elects its own officers, and commences the work assigned to it. On the floor of the convention, each state has one vote. The convention decides whether to propose one or more amendments, and if it decides to do so, it drafts them. The proposals are ratified or rejected in the same manner as congressional proposals are. On several occasions before this learning escaped us, state legislatures flexed their Article 5 muscles by applying in a concerted manner for a convention for proposing amendments. At the turn of the last century, for example, the states forced the United States Senate to agree to the 17th Amendment, direct election of senators, when 31 of the necessary 32 applied for a convention limited to proposing a direct election amendment. If recent history tells us anything, it is that we are not going to restore federalism or for that matter, federalisms, merely by choosing presidents, members of Congress, or Supreme Court justices. The state legislatures will have to do the job. And as James Madison pointed out late in his life, their ultimate constitutional tool for doing so is the procedure of Article 5. Thank you.
Thank you. It's a pleasure to be here, a pleasure to be on this panel with so many distinguished colleagues and friends. I wanted to, I guess, provide a little bit of a happier note. I'm a little worried that of the people that spoke, Neil and Heather seem like the only one that are upbeat. So I want to provide a slightly sort of glass half full view of both the healthcare case to a certain extent, but also on federalism more broadly. And I'd actually, I suppose, start with last Tuesday, which is that, before anybody says that federalism is gravely imperiled and that the role of the states is really, on the ropes, I mean, just think about the Electoral College and just think about the way everybody was counting votes and cared very deeply about Ohio and Florida and Virginia and North Carolina. And, it'd be simple enough to have a popular vote, but that's not the system we have, and it's not the system we have because of the Constitution. And it's a system that really does continue to give an important role to the states. When there was some talk that there might be the dreaded popular vote, electoral vote split, I tried to explain to my boys that if that happened, you should pay no attention to the popular vote. It's like at the end of a football game. If your team loses 28-21, you don't say, but we gain more yards. I mean, yards are interesting, but they're not the relevant metric of whether you win or lose. And obviously, if they were, presumably there would have been a lot more television dollars spent in California. But people in that great state were spared what those of us in Virginia and my home state of Wisconsin were inflicted. So federalism does continue to matter. And with that sort of observation on Tuesday, let me then move to the healthcare decision. And let me say why I think that, although I don't really want to be too Pollyannish about this, I do think that the decision was actually an important vindication of federalism, obviously to an extent. Not to the extent that Randy and I were hoping for, but to an extent. The first, and this I think is really the headline here, it's important to remember the individual mandate was struck down as unconstitutional. I know that's not what the paper said the next morning, but there were 5 votes to strike down the individual mandate that Congress actually passed as unconstitutional. And this is an important point because the Chief Justice, in his opinion, decided the Commerce Clause question and the Necessary and Proper Clause question and said that the statute that Congress actually wrote was in excess of Congress's power. Then he did the second move that Neil alluded to, which is the rewriting of the statute or the saving construction of the statute. Now, when he did that, he was, of course, criticized by Justice Ginsburg, who said, look, Mr. Judicial Restraint, what are you doing deciding the commerce power issue and the necessary and proper issue if you're ultimately going to uphold this statute under the taxing power? Generally, principles of judicial restraint would suggest that if you're going to uphold it anyways under one of 3 powers, then all you do is say the law is constitutional under the taxing power and go home. The Chief Justice responded to this specifically and said, no, I have to address the commerce power and I have to address the necessary and proper power because those are the only powers that actually support a mandate to purchase insurance as opposed to a tax on the status of not having insurance. And so I have to consider those to consider the constitutionality of the statute that Congress actually passed. So the mandate itself, as opposed to a tax on the status of being uninsured, was in fact invalidated by 5 justices of the Supreme Court. That alone is fairly remarkable. Randy, of course, alluded to the fact that, that 5 votes weren't enough. The reality, at the end of the day, 14 votes weren't enough. Because the challenge for the challengers in this case was really to run the table, not just on the 5 justices who would be receptive to federalism limits on the congressional power, but to do so on each of the 3 arguments that the government had to support the statute. Now, the good news is we got 14 of 15 possible votes. The bad news is you needed the 15th vote. There is, as Heather alluded to, another aspect of the court's decision in the health care decision, which is also an important vindication of federalism principles, and that is the spending power holding of the court. And that was not 5-4, that was 7-2, which is a fairly remarkable fact that there were 7 justices that struck down a part of the law as unconstitutional because of its intrusion on state authority. And this, I think, again, is something that is quite important. What becomes of it in subsequent Supreme Court decisions, I think, will ultimately underscore its ultimate importance. But for the first time, there is now a Supreme Court case that holds that there is a limit on the extent to which the federal Congress can coerce states to accept federal money and federal conditions. And the importance of having some limit there, I think, is underscored by something that Chief Judge Easterbrook pointed to, which is the 16th Amendment. Because once you have the 16th Amendment, and once you have a very different understanding from the framers of the federal authority to collect tax revenues, if there's not some limit on the federal government's authority to say, look, states, we just taxed all of your citizens, and we've just taken all that tax revenue that under the original design of the Constitution you would have been able to tax, and we would not have been able to tax. Now that we've taken all that money from them, we're going to give some of it back to you, if but only if you accept all of our conditions on how you spend it. That, I think, the 16th Amendment and the use of the spending power in connection with it, if there are no limits, poses a real threat to federalism. And I think the fact that the court was willing to at least impose some limit on that, I think could be very significant going forward. In fact, in some ways, I think that may be the more significant portion of the opinion. I rather doubt for political reasons there are going to be a lot of individual mandates passed anytime soon. On the other hand, the federal statutes are rife with spending power legislation. So if there are to be some meaningful limits on that, that will really be the enduring jurisprudential significance of the Sebelius decision. And again, on this, the court was 7-2. Let me just make 2 other very quick observations. One, my friend Neil makes the point that, that there is a lot to be said for a return to judicial restraint and a simple focus on laws being upheld unless they are clearly unconstitutional. And I think it's a very fair point, and I think it's a reflection of the fact that a dedication to judicial restraint or not is something that really doesn't have a particular political valence. And if you lose at the election booths and you believe in judicial restraint, then you're going to have to get used to some legislation that's not going to be passed. So for the most part, I have a lot of sympathy with what Neil said. I would take issue with one thing, though, which is his criticism of the Chief Justice's opinion when the Chief Justice, and the 4 dissenters did this as well, emphasized that the law was unprecedented. Because I think that only tells half of the tale here, which is, sure, the fact that a law is unprecedented does not alone suggest that it's constitutionally dubious. I mean, a law might be an unprecedented regulation of the internet, but the fact that it's unprecedented doesn't really suggest much because there was no internet until very recently. On the other hand, if a law is unprecedented and it exercises a congressional power that would have been highly attractive for Congress from the very beginning of a republic, and no Congress ever exercised that authority, then that particular dog that doesn't bark, it seems to me does have some significance in interpreting the document. And if there's a criticism of the Chief Justice's opinion, I think it's that while he recognizes that for purposes of the commerce power and the necessary proper power, when he turns around and gets to the taxing power, he not only doesn't apply the same principle, because a tax on not having health care, I assure you, is unprecedented, but he actually flips it entirely around, and when he rejects the argument that the health care provision as construed as a tax would be an impermissible direct tax, he says that, well, this law doesn't come within either of the 2 categories we have of recognized direct taxes. Well, why is that? Because it's unprecedented. We've never had something like this. So sure, it's not a direct capitation tax, and sure, it's not the other taxes that have come within the category of a direct tax, but it is something that I think, as an original matter, would be very hard to understand as something other than a direct tax, and the fact that Congress never passed anything like it seems quite significant. The last thing I'll say is just to comment on one thing that Heather said. I think her comments are also a good reminder that federalism is itself, like judicial restraint, not something that has any inherent ideological valence. I mean, if you like the national government and you're in a state where you're in the political minority, federalism can be kind of a pain. But if it's flipped around, then federalism is a great virtue. And I think it's, both her comments and Neil's comments are, I think, a great reminder for people to really focus about, are they dedicated to these principles as a matter of constitutional belief, or are they dedicated to these principles as a matter of convenience? I think, based on my experience with this organization over the years, that it's the former, not the latter, but I think it's a very fair question to ask. Thank you.
All right. I think we've got a number of themes going on. If I could read the podium a little bit and try to coalesce those themes for purposes of the response of the panelists to one another. The first, I think, is that the healthcare case has brought us a new doctrine, and there may be some disagreement about that at the podium. I suspect that there is, but the doctrine being summarized as one that shifts the burden and applies heightened scrutiny to legislation that at least seems to exceed the terms of the New Deal settlement. And against that, we have an appeal for a return to Federalism and the impulse of judicial restraint, which I think probably begs the question of what is meant by judicial restraint, whether that's a default position of deference to the political branches for its own sake, or deference to the text of the laws enacted by the political branches interpreted according to traditional sources of legal interpretation. So we can talk about that and have some response on that theme that seems to be prevailing from the podium. We also have a discussion about regardless of the constitutional structure, as a matter of economics and regulatory reality, the states have much reduced authority, and a debate about whether or not they have abdicated what little they have left, or whether that authority can be recovered and how it should be recovered, whether by reconceiving what federalism means. And I think the discussion about how to read the spending clause opinion in the healthcare cases is important in this respect as a doctrinal matter going forward. It did appear to retain the understanding that spending clause legislation is essentially conceived of properly as a contract between sovereigns as opposed to principal and agent, and that's going to be the debate going forward. And then we also have a proposal from Rob Nadelson to never mind the doctrinal tinkering, let's blow the thing up, basically, and the states should simply invoke their constitutional authority under Article 5. I told you he was a political provocateur, and go that route. So I think that is sort of a summary of the three themes that we have going on here, and with that, I assume that, Randy, you probably want to respond to what Neil said and perhaps some of these other ideas as well.
Thank you, Judge Sykes. Yes, I want to respond to what Neil said, but before I do, I first want to, in case it gets lost in the shuffle, I want to express my agreement with what Rob said about Article 5 conventions. I agree with everything that he said about Article 5 conventions. It is a lost knowledge, which no one has done more than Rob has in restoring our understanding of, or beginning to restore our understanding of, and it's a very important structural constraint on federal power that has been neglected. We have to look to the Constitution for the structural constraints that are there. This one was there. It was put in there for a reason. It was put in there by the founders, and it should not be forgotten because of some misunderstanding about what a convention for purposes of proposing amendments is really supposed to be, which is really what has happened for somewhat political reasons. So I just want to underscore that because it's likely, because Rob is a somewhat odd person out in terms of the theme of his talk, it's likely to get lost sight of in our discussion. I wanted to lead with that. I also wanted to underscore what Paul said. Which is something, if there's one takeaway from this conference, for all the people in this room, it should be what Paul said about the fact that the individual insurance mandate was held unconstitutional, because that is not how it was described in the press, and it's not how it's been discussed by law professors since then, and I suspect it's not how a lot of people in this room have described the decision. There is no insurance mandate anymore. The requirement, to quote the statute, is not a requirement. It is an option. And because the requirement would have been is unconstitutional, that's why it had to be reconstrued as an option. And I think we have to stop talking about the fact that we have to stop characterizing this opinion as the individual insurance mandate was upheld under the tax power. That is not what the court said. It's not what the fifth vote, it's certainly not what the 4 dissenting justices said, and it's not what the 5th deciding justice said. And so there are not 5 votes for that proposition, and so everyone should pay close attention to what those 2 speakers said, I think. Now, just in responding to what Neil said, and I'm going to do it really briefly, I want to start with Heather's discussion of the principal-agent relationship, because I think it's really quite telling that she described the principals in our constitutional order as the federal government, and the agents as state governments. When in fact, I think according to the baseline established by the Constitution itself, it's the people who are the principals, and it is government at all levels who are the agents. So if you start with that as your baseline, instead of the baseline that Heather started with, then what does that tell you? And I think partly it tells you, well, how is it that the principals, who are the people, get to constrain the power of the agents, their agents who are the governments? And the device that the Americans invented to do this was a written constitution, something that hadn't been tried before, at least not the way they did it. And the idea here is that they would put into writing the constraints that the principals, the people, would put into writing the constraints that were going to be imposed on their agents, who in this case was largely the federal government, with some constraints on the states, which ended up getting amped up later on during the Reconstruction amendments. Then there was more constraints on the agents that are the states. And as a result of that, the agents would be controlled. Now that only works if those rules are followed. If those rules are ignored by the agents, this doesn't work. Now, in our system, who is it that's responsible for seeing to it that these rules are followed? For better and for worse, we have the structural sort of constraints that Rob is talking about. For better or for worse, within our federal structure, it is the judiciary who is there to see to it that the branch of government where Madison said the greatest danger lies, which is the legislature, because the legislature in a Republican form of government represents the greatest power, which is the majority, and so that's where the greater danger lies. It's the judiciary and independent tribunals of justice, in Madison's words, who were there to adjudicate a dispute between the principals, which are the people, and their agents, which is the federal government. And I think if we adopt the capacious view of McCulloch versus Maryland, which the progressives urged upon us and which Neil talked about, which is essentially that the federal government has power to do anything that in its discretion it needs to in order to effectuate its national powers, anything at all, as long as it's necessary. If you read McCulloch that way, I don't read McCulloch that way, but if you do read McCulloch that way, you're essentially flipping the relationship of principal and agent. And you're basically saying, you're creating the agency cost problem that Heather's talking about in a different context, and you're basically saying that the federal government now ends up calling the shots. And the only institution that stands between the principal, the original principal, which are the people, and them, which are the independent judiciary, the independent tribunals of justice, or the judiciary, they have to sit back and they have to let it happen. I just don't think that is the structure that we have. I think we are actually moving towards a position in which the judiciary is feeling empowered or feeling that they're entitled to follow their duty and respect and follow the Constitution. And so I reject that. But I do think I do think this represents a fundamentally different view of who the principal is, who the agent is, and what the role of the judiciary is in enforcing those rules.
Chief.
I have a few words on the discussion actually between Randy and Neil about what is the judicial role. I get worried when people talk, as Neil did, about judicial deference or judges being respectful of the political branches of government. The implication there is that judges pick up the Constitution, they figure out that something is unconstitutional, and then they say, yeah, but for policy reasons, we're not going to do anything about it. That's fundamentally troubling to me. But also troubling to me is Randy's suggestion that part of the original plan was that judges are going to enforce the federalism rules, and indeed all other rules, against the political branches of government. My copy of the Constitution does not have a judicial review clause in it at all. It's just not there. If you remember in Marbury against Madison, judicial review is teased out of the structure of the Constitution. out of the fact that the Constitution is, in some respects, it's got some real legal rules in it, and then it's got some structural organizational rules about how everybody else is going to behave. And the Supreme Court said in McCulloch that when the Constitution's got real legal rules in it, they're superior to what's been done by the agents under it. I certainly agree with Randy that the principals are the people and the government is agent. That's the original understanding, I think, and where we get judicial review from is this structural argument in Marbury. And now, it seems to me, important to ask, what is the original understanding of judicial review on questions of federalism? I mean, I think that we judges are supposed to implement the original public meaning of the Constitution. That, of course, has been Randy's position for a very long time. We're supposed to implement the original public meaning. One of the questions about original public meaning is what is the relation between the judicial branch and the legislative branch on questions of federalism? And I think McCulloch tells us not what is a good thing for Congress to do or how the balance is struck between Congress and the states. What McCulloch tells us is what is the relation between the judicial branch and the legislative branch in adjudicating matters of federalism. Because McCulloch, you will all remember, dealt with the validity of the Second Bank of the United States, a novel institution if ever there was one, because there isn't a Bank of the United States clause in the Constitution. The holding of McCulloch is not that this was good or bad, but that as between the judiciary and the legislature, the power had been given to make this decision to the legislature. The alternative, Chief Justice Marshall said, and by the way, he was writing not only for himself, for the Federalists, but for the Jefferson and Madison appointments on the Supreme Court, that is, for the Republicans. What he said in that case is, if we understand the necessary and proper clause to make the judges the determinants of what is necessary and proper, then the judges really have a legislative power. And the original structure of this deal was that those decisions had to be made by the elected people. But what I take from McCulloch is not a proposition about what is right or wrong as a matter of federalism. It's a proposition about what is the role of the judicial branch in making decisions about federalism. And on that, I think, we learn what the original public meaning of the Constitution is. I get very worried when somebody says, aha, the founding generation didn't actually understand the original meaning of the Constitution. Nor did anybody who lived before the 20th century. But somehow we figured it out in the 20th century. My view is that this probably means that what we figured out in the 20th and 21st century is different from the original public meaning. I think we need to implement the meaning that was believed in by the people who wrote and approved that document.
So to respond to the last, and this underscores that this is not a left-right issue. I completely want to associate myself with Chief Judge Easterbrook's comments, which I agree with. So responding to the point about people versus agent, principal-agent problem, Randy, I completely agree. The baseline is the people. The people are the principals. Government is only the agents. We, the people, establish and ordain. So that, I think, is undoubtedly true. Now, the will of the people is expressed messily, no doubt. But elections are, it seems to me, the founder said, are the best way to express that will of the people. And the fundamental insight of, to me, the Federalist Society for a quarter century has been that judges, relatively speaking, are the worst way to try and get at the will of the people. And so that's why I think that's where that idea of judicial restraint, I think, comes from. Now, with respect to Paul's comments about the anti-novelty canon and kind of the dog that didn't bark, it seems to me a very dangerous principle to say that just because something hasn't been done, even if it was a shiny and attractive bauble that the founding generation might have wanted to do, that somehow makes it unconstitutional. That is not rooted in the text, structure, or history of the document. There is no Burkean clause in the Constitution. And indeed, as Chief Judge Easterbrook just said, I think actually that the original understanding of the Constitution is much to the contrary. McCulloch says that the Constitution is adapted for ages to come, that it is flexible, and it prescribes a rule of decision for judges to use, which is to let the process unfold, to not just say something, oh, it's new, therefore it's unconstitutional, but to actually examine, does this piece of legislation contravene a clear text in the Constitution? If it doesn't, then it should let that political process unfold and vote that out at the ballot box. And then factually, I'd be really worried about Paul's rule because we have no idea why the founders may have not adopted a particular method. They might not have actually found it attractive or not, some policy measure attractive or not. They might have not done it for matters of policy, for matters of politics, who knows? That just seems to me to lead to any number of questions that I think courts particularly are not well equipped to address.
I just want to defend Neil a little bit on the judicial restraint point and respond in part to Paul's point on the Commerce Clause ruling. And I have to say that Judge Reinhardt of the Ninth Circuit, I imagine you're all reasonably familiar with him. He's the last Warren Court judge still standing. He once wrote an opinion about splitting a sentence in the underlying conviction. He was worried that by allowing the defendant to do so, that a future court might decide that he wasn't allowed to do so and punish the guy essentially for what the appellate panel had decided to do. And so he wrote a footnote in that opinion that said, we hold that this is not dictum. Now, I will just say that when I read Chief Justice Roberts' assessment about why he was going to talk about the Commerce Clause question, I, in the back of my mind, heard the phrase, we hold that this is not dictum. So with all due respect, I understand that there is a technical argument for it, and I don't want to downplay Paul's analysis because no one knows it better than he does, but I do think that the spirit of judicial restraint suggests that the Commerce Clause argument shouldn't have been in that opinion. And I say that as someone who thinks actually the Commerce Clause argument isn't going to matter that much. This is where Paul gets it exactly right. It's a Spending Clause argument that's going to matter, that's going to be salient. The Commerce Clause argument, unless the court continues to expand on it, is, I think, not going to be one that's going to have a huge influence on federal-state relations. And I just want to, again, say something that Neil said. My generation believed you when you said you believed in judicial restraint. And we believed you because we thought it was a principled position. If you abandon it for political reasons, you're going to lose the moral high ground on this one. And it's a question, I guess, for your society as to what you want to do on that question. But if you've won an argument and you've done so on principled grounds, I'm not sure why you'd want to abandon it. The second thing, and this is again a little bit as an outsider watching all of you spend your time, and particularly my wonder students, some of whom are in here, in terms of what you're going to do with your time. I loved Rob's talk. But I have to say that I did have this feeling that I often have when I'm with members of the left who are outraged by another case that you probably know about, Citizens United. And they really want to amend the Constitution. And every time they tell me this, I tell them it is a complete waste of their time. And that they would be better to spend their time fighting about politics, because the politics eventually will shape the judicial environment in which these decisions are made. And so the other thing about liberals is that they always go to court to get what they want. And so it's sort of bewildering to hear the FedSoc folks talk about going to courts to get what they want. So I'm sort of torn, and most of what you want, I don't want. So maybe you should spend a lot of time amending the Constitution and looking to courts for assistance. Or maybe you might think about working on the politics side.
Okay, well, first on the issue of judicial review and its legitimacy. Judicial review did not originate in Marbury versus Madison, nor is it rooted purely in the structure of the Constitution. It was well understood as an institution when the Constitution was adopted. It is mentioned in Federalist number 78 by Hamilton that the courts would void laws that were unconstitutional. There was extensive discussion on the subject at the Virginia Ratifying Convention, in which anti-federalists said, hey, look, what happens if the federal government exceeds its powers? And the response came back from, among other delegates, John Marshall, that then the courts will strike down the laws that exceed the Constitution. And the response of the anti-federalists, like Patrick Henry, is, let's hope so. We recognize that the Virginia courts have struck down unconstitutional laws. Let's hope that the federal courts do so also. Dean Traynor of Fordham Law School in 2005, in an article in Stanford Law Review, identified something like 32 cases before Marbury versus Madison in federal and state courts, including a fair number of them before the Constitution was ratified, in which judicial review was acknowledged or applied. It was actually a concept that went back to practice under the colonial charters. Secondly, I would like to take, as a matter of personal privilege, defend myself against the charge of being a provocateur. I do not want to blow up the system. If you look at the size of the federal debt, Congress is doing a pretty good job of it itself. I would also like to defend myself against the charge of being a visionary. It would certainly be visionary to claim that the states, through the Article 5 amendment process, are going to return us to the pristine days of 1787. I don't think I would want them to do so. However, the fact is that at one time, not too long ago, we already had 32 of 34 states, one shy of those necessary to apply for a convention for proposing a balanced budget amendment. Now, that crested for a number of reasons, including charges that the proposed convention would be a constitutional convention, based, as I mentioned earlier, on ignorance of the historical record and of the law. But we still have something like 15 applications out there right now, which means we need 19 more. This is far more, I would say, than the advocates of repealing Citizens United have. And in fact, we just got another one. New Hampshire just applied for one. So I would, at the risk of being a starry-eyed romantic, I would say probably the odds are about even that in the next 10 years we will get a convention to deal with some discrete federal issue, probably fiscal. Professor Gerken's contribution in the area of federalism, in part, has been pointing out that there are different kinds of federalism. There's what she calls sovereignty federalism, which is sort of divide up the turf federalism, which is what we usually think of as being it. There's cooperative federalism, there's the servant role. What's interesting here is that all the kinds of federalism that she identifies actually are in the Constitution. When the state courts apply a federal law, they engage in the servant role of federalism. When the states trigger Article 5, for example, they engage in process federalism. There's also a significant area of sovereignty federalism, and Professor Gerken has pointed out that sometimes sovereignty federalism can be a valuable bargaining chip when you're negotiating with the feds over some issue or other. Where I think we would disagree, however, is that where all types of federalism occur in the Constitution, I think we would disagree with where the balance is. I would argue that there's a lot more sovereignty federalism in the Constitution than many progressives would acknowledge.
So I'll just make 3 points to close up this round, so to speak. Neil points out correctly that there is no Burkean clause in the Constitution. But of course, there are this whole process in Article 1, Section 8 of enumerating limited and enumerated powers. And I have to say, if you go through that list and look at everything that's in there, coining money, postal roads, and the like, it's an awful lot of trouble to go through if the commerce power actually gives the federal Congress plenary authority. It really was a waste of time. So I think when you're looking at the judicial role in interpreting federalism, it's not about interpreting either the Burkean clause or the Federalism clause. It's about interpreting the scope of the authority given to Congress under Article 1, Section 8. And that's a difficult process. That's a difficult judicial role. And that's why I think looking at whether or not the asserted authority or the challenged authority is something that Congress has used without interruption since the framing or has never used, despite the fact that it's a highly attractive power, is certainly a relevant judicial tool. I think it almost has to be, because at a minimum, it's relevant in that it's the absence of a long pattern of using a power, which, as Chief Justice Easterbrook points out, would be strong evidence of the original public meaning of the Constitution. So when you have an authority that hasn't been used, that at least tells you something, that the challengers may have a point, that that power is not included in the limited and enumerated powers. Second point, I just make a pitch maybe for a future Federalist Society conference on this idea of judicial restraint. Because, and maybe it's because I'm, rough contemporaries with Neil and Heather, but I agree with them. I mean, I think when we were, in law school, what the Federalist Society stood for was, among other things, and, there were always, Manny has been, virtually a founding member, so it's never been sort of one mind on this, but I think a big principle was judicial restraint. And I think the Federalist Society, again, as they said, has been incredibly successful in making that point and making that principle. You succeeded in the world when people try to pull Orwellian tricks on you and basically say, oh, judicial restraint, that's in the eye of the beholder. That has no intellectual content. That's just somebody's way of describing a judicial decision they like, and judicial activism is just a way of describing a judicial decision you don't like. I don't think that's true. I think judicial restraint has meaning, and I actually think it would be useful, perhaps, for the Federalist Society to try to explore kind of what we mean by judicial restraint, because it's obviously it's an only principle worth fighting for if we know what the principle stands for. The last point is just, and this is really something I should have mentioned earlier, but there's been this discussion about who's principal and who's agent in these various relationships in the Constitution. And I think that's one thing I would say is why the spending power issue is so important, is because I'm very intrigued by Heather's point that there are ways for states to assert their authority through uncooperative federalism, even in the context of federal programs. But there's a problem with that, which is that the way the spending power operates, it has state agencies basically advertising to the world that they're state agencies, implementing federal power and implementing federal programs. And that, if you think about federalism largely as being, among other things, about accountability, that's a real problem. As the discussion on the panel shows, the one thing you need to have a principal-agency relationship have any hope of working is some agreement as to who's the principal and who's the agent. And so when the citizen gets hacked off at the State Department of Health and Human Services because they've just imposed some outrageously stupid rule, it's a problem if the basis for that rule is federal law, but nobody knows it. They're hacked off at the state and local official. And, I think it's an interesting thought experiment. If you forced the federal government, and I'm not suggesting this is going to happen anytime soon, but if you forced the federal government to actually implement these broad sweeping programs through federal administrative agencies in the states, as opposed to allowing the federal government to hide the scope of its reach by implementing them through state agencies, whether the people would have the same level of comfort with the degree to which the federal government is intruding in every aspect of our lives.
All right, thank you. I'd like to offer the panelists an opportunity for rebuttal or final comments before we throw it out to questions. Anybody? Not on this side? No? All right. It's now time to take your questions. There are microphones on all three aisles. All right. Yes, sir. A regular.
Thanks. And this year I hail not only from Rhode Island, but from our newly formed Stephen Hopkins Center for Civil Rights, where we participated at the First Circuit in a case that I think raises very important federalism issues, but unfortunately is being litigated on kind of pedantic statutory grounds. And that brings up the question of deference, I think, to prosecutorial discretion. Where does that on the criminal realm fit in with judicial deference? This is a case that's coming to a Supreme Court near you, U.S. v. Plow, where Governor Chafee, who has that kind of occasionally right clock syndrome, he's still analog and he's right a couple times a day, is fighting the federal attempt to prosecute a criminal for a robbery on federal grounds. And I just think it raises really, really important questions that may cross the ideological bounds about the vast array of prosecutorial discretion that seems to go begging, other than the circuit split in the 8th an internal circuit split in McFarland and Hickman. I'm wondering if anybody could bring it into that realm or if I've journeyed too far.
Who would like to take that question?
I can't. There's an ethical rule that says judges can't comment about pending litigation, so I'm out.
Would anyone like to comment on that as a broader issue, prosecutorial discretion and where it fits into this discussion of federalism?
Yeah?
I mean, I'll throw one observation out about that, which is to say, I think, prosecutorial discretion perhaps ought to have a role, but I mean, I'm not sure that one should have too much hope about it. And I'm actually familiar with the case you're talking about largely because, I was arguing a different case the day in the First Circuit, the day that case was argued. And I think you're right. It is being argued on relatively, interstate agreement on detainers clause, which is fascinating. But it really hasn't sort of teased out the issue as a pure sort of federalism. But so I'll beyond saying that, I will say as to prosecutorial discretion, a great example of sort of the possibility unrealized of prosecutorial discretion playing an appropriate role in federalism is another case that's sort of lingering on the court's docket. It's been relisted twice that I'm involved in, which is the Bond against the United States case, which is a prosecution that the federal government decided to bring under the Chemical Weapons Implementation Act of 1996. And this is a domestic dispute in the pure sense of the word that involved the use of some chemicals in a malicious way, and it would seem to have been I think there was poisoning going on even in the framing generation, and this would have seemed to have been a classic example of a case to be brought by state or local authorities or not at all. But the U.S. Attorney's Office in Philadelphia decided that this would be a great opportunity to bring a prosecution under this Chemical Weapons Convention Implementation Act. The idea that my client had used a chemical weapon, and therefore it was a matter for the federal prosecutors. And that's the kind of thing that happens. And so, anybody who sort of, scratches their head and says, well, these are hard questions for the judges to get involved in and to lay rules down, that's right. It is difficult, but I think it's important because you can't just leave it to the prosecutors.
I'd just say two quick things.
This is actually a very interesting topic in Colorado and in some other states like Montana, which have legalized medical marijuana. We've gotten conflicting messages from the Obama administration as to what extent they're going to be enforcing the laws against medical marijuana, which they can, of course, under Gonzalez versus Raich, ably argued by Randy Barnett, which in fact they can.
More ably argued by Paul Clement.
Generally, the feds have been pretty circumspect, I guess, because it seems like we've got a medical marijuana dispensary on every corner now. The patience of the feds is going to be tested even more because we just completely legalized marijuana, and this is going to be an interesting. It's going to be an interesting ride, I think. You mentioned the Stevens Hopkins Center. That's the name of it.
Yeah.
One of our lesser-known founders. Remember in my principal talk, I mentioned that there had been all of these other interstate conventions held before the Constitutional Convention. Stephen Hopkins attended a number of them, and in fact, he chaired 3 of them.
Just a word on Paul's case, Bond versus United States, because it does raise actually a big question we've been talking about for the first hour, which is the limits Congress can have under Article 1, Section 8 to criminalize things. And really, the case tees up Missouri versus Holland. And if you haven't read Nick Rosenkranz's amazing Harvard Law Review article on this subject and the limited conception of the founding and criminal law versus the way that Justice Holmes and others expanded it, it's a fantastic read. And perhaps will be litigated this term.
All right, thank you. Let's go to this side of the room.
Thanks. Ilya Shapiro from the Cato Institute, and Nick Rosenkrantz operationalized his article into a brief for Cato between that and Paul's cert petition and a brief opposing, an amicus brief opposing cert. I mean, it's been relisted twice now. We'll see what happens. Hopefully something will happen on it. But my question is about the taxing power. When I've been going around doing commentary on the Obamacare ruling, I've said that Chief Justice Roberts posed himself the conundrum of how to uphold the law without expanding federal power, and essentially succeeded in doing that, and that includes on the taxing power. Cato's actually going to have a conference in the spring on this. but I'm curious what the panelists have to say about whether the taxing power is somehow expanded or expanded in a way that will simply never be used again, didn't change anything, or otherwise.
All right, future of the tax power.
Well, I mean, Paul, I'm sure will want to speak to this, but yes, it was expanded. I mean, I agree with what Paul said earlier. I mean, it is a tax on inactivity that is unprecedented, and I think it's a quite dangerous power, and it's unfortunate. It is the least dangerous of all the powers that could have been recognized to uphold the act, because he didn't allow for an unlimited tax on inactivity. In fact, it had to be a non-punitive tax. And he built into his holding the idea that if it gets too high, if it gets too punitive, then the courts can revisit that, because you can't have confiscation by taxation as long as the courts are in session, as long as there's a court. So again, it was reserving to the judiciary the ability to distinguish between a punitive tax and a compensatory tax. Essentially what he said was the reason why this tax was okay is it preserved the option of buying insurance or not buying insurance, because it didn't cost any more than the insurance would cost, and so you'd have a choice. If it actually got any higher than that, it would punish you for not doing it, then it would be unconstitutional under the tax power, unconstitutional. So yes, it was an expansion. It was not an unlimited expansion of the tax power, and whether in the whole opinion, frankly, it has a this day and this train only quality to it, which is that somehow we have to uphold this law. How can we uphold this law while doing the least possible damage? And in fact, by doing some good, and that's what happened. And so, but because our argument was that upholding this law was going to require an expansion of federal power, it did require an expansion of federal power, but only the most limited one that he could come up with. One other thing about that theory that he came up with, I mean, in terms of whether this was a reasonable decision or not reasonable decision, and I guess we can argue that ex post, but there wasn't another judge who heard this case in all the circuits who considered this case, who thought that the argument that Justice Roberts came up with was persuasive. That there wasn't a single other judge on any panel who was attracted to that argument. There was not a single other justice on that court that was attracted to that argument. That argument, if it really was persuasive, happens to have been discovered and found persuasive by only one judge who heard this case and all the litigation that took place over 2 years.
Chief.
There was a dispute in that case about whether this particular monetary exaction was a tax. But I don't think it's right to say that there was anything unprecedented about using the taxing power to achieve regulation. It's been a long time since it was strange to talk about the exceptions and deductions and rebates and credits in the tax code as anything other than tax expenditures. The tax code is just full of clauses that tax particular things in order to discourage them, that reduce the taxes on other things in order to encourage them. And once you conclude that this was an exercise of that taxing power, it's actually perfectly normal. Now, one can bemoan the fact that much of what the federal government does in regulation is buried in the tax code, and that it looks like things that it's not doing as much as it is. But those of you who were at one of these meetings perhaps 20 years ago, where there were proposals to have, say, a balanced budget amendment as a means of controlling the size of the federal government, many members of panels were saying things like, balanced budget amendment won't do you any good because anything the federal government can do with explicit expenditures, it can do through the tax code and keep it off the budget. Well, that's been true for a very long time. So I think the only thing that was going on in this particular case was a decision whether Congress had exercised that particular power or not.
Right, Paul, is there a distinction here to be drawn between a tax on minding your own business and credit as an inducement to engage in a certain activity that's favored?
Yeah, no, I actually think there is, and I think the Chief Judge is quite right that that certainly tax expenditures are not unprecedented, but I do think a tax on inactivity is unprecedented, and I think if there's a real sort of petite tragedy here with the court's disposition here, it's that there wasn't re-argument on the question of whether, if the court was inclined, or the Chief Justice, as the decisive vote, was inclined to reconstrue the individual mandate as a tax on the status of not having insurance. It's a shame there wasn't re-argument that really focused on the question of whether or not that was a permissible direct tax. Because I think if you look at that, and maybe the Cato Conference can cover that, I mean, you know, there isn't as much sort of work on the original public meeting of that as I wish there was, based on what I was able to find in preparing for the argument. But I think what I was able to find shows that, you know, that prohibition on unapportioned direct taxes really was another structural protection for federalism, because the idea, and it was very related to commerce too, because the idea is, okay, the federal government's going to be able to raise its revenue based on direct taxes, excise taxes, duties, things like that. And if they already have the power to regulate commerce, the power to raise revenue through, taxes on like excises and things like that, you know, that those sort of go hand in hand. But the idea was the power to have direct taxes, like income taxes or capitation taxes, would belong only to the state governments. And since that's where, in some ways, I think the framers incorrectly thought the real money might be, they thought that was another constraint on sort of federalism. And that's why I do think that the framers would have had a very different reaction to a tax on inactivity than compared relative to a tax on activity. You know, the issue that divided the framing generation on the direct tax clause was whether a tax on a carriage was a permissible direct tax or an impermissible indirect tax. I think the real question here is, what if they had tried to have a tax on not having a carriage?
We've got them. In fact, I pay them every year. Let me give you two examples of my inactivity. I'm not married, and unlike Leonard Leo, I don't have 7 children. Under the tax code, my inactivity in not getting married means I pay a higher marginal rate than I would if I were married. And not having children means I don't get the deductions or credits available for children. It's perfectly easy. It's perfectly normal to write the tax code that says everybody pays X, but if you engage in the following activity, you pay less, right? That's exactly economically identical to what went on in the Affordable Care Act. It's identical to saying everybody pays a slightly higher marginal rate, and if you demonstrate that you've got insurance, you get a credit or a deduction. That's the fundamental structure of the tax code. There's just absolutely nothing interesting going on here.
And I don't want to get in an extended debate because the Chief Judge sits on my cases and not vice versa. But but I do think there is a difference between a tax on income that is then adjusted in ways that reflect your various activities and inactivities, and a tax directly on inactivity, which is what you would have in the hypothetical tax on not having a carriage, and what I think is the way to understand the law that emerged from the court's majority opinion.
Right.
Mercifully, I live outside the Chief Judge's circuit, so the question is to the level of how unprecedented this was. You have to look at two different issues. First, is this truly a tax? And secondly, if it is a tax, is it a direct or an indirect tax? Again, from an originalist standpoint, the founders would have said, if the measure is imposed primarily to raise revenue, it's a tax, even though it may have incidental behavioral consequences and may even be imposed with knowledge of and desire to have those incidental behavioral consequences. On the other hand, if its primary purpose is to influence behavior, it is not a tax, it's a regulation of commerce, even if it may incidentally raise a little bit of revenue. Using that test, this was a regulation of commerce, not a tax. Now, it is also true that subsequent Supreme Court case law has muddied that distinction, which was a very important one to the founding generation. It's part of what the revolution was fought over. So you can make the argument, though, based on the intervening case law, that the tax finding was not unprecedented. On the other, then you have the direct versus indirect, and this, I think, is the weakest part of Chief Justice Roberts' opinion. Basically, the difference between a direct and an indirect tax is actually a lot easier to recover than a lot of writers assume. Basically, a direct tax is one that is imposed upon you for just existing or for earning a living. As Chief Justice Roberts pointed out, There are taxes that are imposed for just existing. Capitations are, and he gives that an example. Well, yeah, but the capitation is a direct tax. It's not an indirect tax. The income tax is a direct tax, but it's been preserved from the need for apportionment by the 16th Amendment. So I thought that part of the opinion was quite weak, and I think from a standpoint at least of an originalist viewpoint, this is, if it is a tax, it's clearly a direct tax.
All right, let's take another question, Professor.
My question is for Professor Katyal and Judge Easterbrook. I wonder, doesn't federalism judicial review in some sense solve the counter-majoritarian difficulty in the following way? When the court decides substantive due process cases or individual rights cases, as in Roe versus Wade or Lochner against New York, it holds that no level of government, neither state nor federal, can take a particular action. So there's a counter-majoritarian difficulty and need to find that a right is deeply rooted in the text, history, and tradition before a majority is disempowered from acting. In federalism cases, the question is jurisdictional. Which majority, a state majority or a national majority, has jurisdiction over a particular question? And in a separation of powers case, there's also, I think, the same phenomenon. Is something confided to the majority of the American people that elects the president, or the differently constituted majority of the American people that elects Congress? In teaching comparative constitutional law, I have noted that judicial review seems particularly to arise in federations and separation of power systems because of the need for a court to play umpire between the nation and the states, or between, as in France, the president and the parliament. So I wanted to ask, Professor Katyal and Judge Easterbrook in particular, doesn't judicial enforcement of the structural constitution solve the counter-majoritarian difficulty?
I don't know. I must say, although I like Alexander Bickel, I've never been impressed by the concept of the counter-majoritarian difficulty, in part because I've always agreed with the rationale of Marbury that when the Constitution is law, the judges are supposed to carry it out, and when it's not, they're not. I'm a little surprised, Steve, that a founding member of the Federalist Society was able to say the phrase substantive due process without choking. My copy of the Constitution just doesn't have it in it. The problem is not some counter-majoritarian difficulty, but that the entire line of substantive due process cases has been made up out of whole cloth and is 100% illegitimate. Roe against Wade is wrong not because of the counter-majoritarian difficulty, but because there's no clause in the Constitution that it's enforcing. So that's my difficulty. There are, of course, real structural provisions. If you think about things where there is real law, think about Chadha against the Immigration and Naturalization Service. That's the one-house veto case. The Supreme Court picks up the Constitution and says, look, there's a provision about how Congress makes law. It's two houses of Congress followed by presentment to the president. And if you don't do that, it doesn't count as law. Congress can act only through joint decisions of the two houses and presentment. I mean, that's something within the scope of Marbury. This more general federalism concern, I think, the original public meaning is the one understood in McCulloch. But I get there not by worrying about counter-majoritarian difficulties, but by trying to figure out as best I can the original public meaning.
So I think that the politics, the founders essentially left us a world which politics is the first check in balancing state versus federal relations, and that's the fundamental insight of the Federalist Society. It's not up to judges unless the case is clear. And notions of substantive due process, I agree, are fundamentally anathema what the society's about. They're not fundamentally anathema, and Randy, correct me if I'm wrong, but to your view, I mean, I take it your view of the Ninth Amendment is essentially that there is a kind of very strong structural due process that is a substantive due process that judges should emphasize, should enforce. And it seems to me the real question is not Bickel's counter-majoritarian difficulty read on its own, but Bickel in connection with Thayer. That is, there's going to be doubts among the left and the right about whether a clear constitutional text was contravened or not. And I think if we can agree, both sides, as a matter of method, that it's really got to be clear that that's the test. And otherwise we let the process unfold, that's, I think, a better way to go forward. Now, you could say, and I take it, Steve, your question is, well, suppose that if it's the Supreme Court striking down an act of Congress, that could still let states enact, for example, their own mini health care legislation, the Massachusetts model or whatever, whereas in Roe versus Wade, when the court strikes it down, they strike down federal and state abortion laws. And so there is something that's less pernicious about the former rather than the latter. Strikes me that's not really the case, because at least in today's world, striking down federal legislation like the Affordable Care Act essentially means you can't do it at the state level, because you have, as Judge Easterbrook was saying, Chief Judge Easterbrook was saying a moment before, essentially competition among states. And no one state could have enacted the health care plan and let it succeed the way that the federal government would succeed. They each had structural disincentives to do so, because any one state that did so would lead other people from outside of their borders to come in and swamp the system.
How does that square with what happened with Massachusetts enacting a health care mandate and not being forced?
Because as the brief by Massachusetts pointed out in the court, that model didn't actually work as well as it would have. Yes, they took the political hit and did it, but it was very hard to do so precisely because of the externality problem that was engendered, and that having a national solution was really effectively the only way to do it.
All right, Professor Gerken has something to add.
So having Professor Calabresi up here, one is tempted to have the Marshall McLuhan moment and ask him about judicial restraint in the Federalist Society, but I just wanted to just draw one distinction, and I have no doubt that Chief Judge Easterbrook decides cases precisely the way he describes, but your Supreme Court does not decide federalism cases in a way that simply involves figuring out which is the right sovereign as if it were a simple jurisdictional dispute that you're refereeing. What the Supreme Court does in many of its federalism cases, which I take it many of you embrace, is discover that there isn't often a textual commitment that identifies with precision which sovereign is entitled to have the power and which isn't, or which institution is. And so they do what we do in a lot of cases, which is we talk about policy, we talk about functional concerns. There's a list that the Supreme Court trots out every time it talks about federalism, about the sort of policy reasons, the reasons that sovereignty, that federalism is good for democracy, that states are good for democracy, and they're squishy. So the idea that there's I do sort of want to resist a little bit the idea that federalism isn't as squishy, as malleable as other parts of the Constitution analysis on the Bill of Rights side. I think there's a tendency to think structural arguments are the rigorous ones, and that the ones on the Bill of Rights that get made by these crazy Warren Court and liberal judges are not the rigorous ones. But I will just say that when I teach these cases, and I believe that law is a craft and that you can tell better and worse cases from one another. But I think that we have to concede that on the separation of powers side and the federalism side, there's a lot of analysis that looks an awful lot like what the court has been doing on the right side.
There's also on the federalism and separation of powers side about 6,000 words, whereas on the 14th Amendment there are 52 words that generate all the individual rights cases. So in terms of the amount of text to consult and to be guided by, there's more.
I don't deny that there's more words. I just want to deny that those words are actually identifying with precision and clarity the answers to the questions that the Supreme Court is often answering. It is often deciding who should have the power, not who does have it.
There are three concepts, three arguments that the progressives conceived of in order to attack the Supreme Court for enforcing the original Constitution, all of which have come up today. The first one is judicial restraint versus judicial activism. This was a concept made up by the progressives. The first person that we know of to use the term judicial activism was Arthur Schlesinger Jr. in a critique of some of the New Deal justices who he thought were not exercising proper judicial restraint. The second one is the power of judicial review. Prior to the 20th century, there was no discussion of the power of judicial review. Philip Hamburger has demonstrated what I think most of us know, and that is, or many of us know, and that is that there was simply the judicial duty to follow the Constitution. The Constitution is higher law, and therefore there's a duty to follow it as opposed to a lesser law, which is legislation. It was the progressives that made up the idea of the power of judicial review, which they then said, well, really isn't in the Constitution, so it's of dubious constitutionality, and therefore it must be restrained restrained. So the idea that we invent a power of judicial review only to find it of dubious authority, and that's in service of restraint, is connected. And the final one is this concept of substantive due process. That was a concept made up by progressives to criticize the enforcement of the Due Process Clause on the grounds that substantive due process was a contradiction in terms, just like procedural due process is a redundancy. What the Due Process Clause had been used for 150 years was to scrutinize laws to ensure that they were not irrational, arbitrary, or discriminatory. And all that that meant was it didn't talk about, there was not a whole tradition of identifying a lot of fundamental rights and then enforcing them. That's not the way the job was done. The way the job was done was looking and seeing whether a particular law was within the appropriate power of the legislature. At the federal level, those powers were defined by Article 1, Section 8, and also, for example, Section 5 of the 14th Amendment, the enumerated powers. And at the state level, they were defined by an appropriate conception of the police power, which was not an unlimited power, because an unlimited power would be a tyrannical power, and no one was in favor of that. So you had to have a theory of the police power and ask whether a particular law was within it, and they scrutinized for irrational, arbitrary, and discriminatory laws to see if the legislature had exceeded its proper powers, something that goes all the way back to Calder versus Bull, if that's just the most famous iteration of this principle. So these are three New Deal concepts made up to critique the enforcement of the original Constitution as it was written, and the public meaning of that Constitution that we still operate within, unfortunately, and I think it holds us back. And it's sort of been throughout this discussion today.
All right, let's take another question over here.
Jim Huffman from Portland, Oregon. On the subject of tyranny that Randy just raised, I was interested in this conversation in almost all the arguments in the courts below in this case. Liberty seldom came up in the context of, one might think of it in the Bond case 2 years ago in the Supreme Court. And so my question is why we've got models of federalism, and the one that dominates, as has dominated this conversation, is the sovereignty model, that is, powers here or there. Where is liberty federalism in this discussion? There are opportunities in this case where you have an individual mandate. Where better to raise the questions of liberty and the effect of government power?
Oh, that's a high lob.
Well, I mean, this was in the case. I mean, it was actually an argument we made from day one. The defenders of the law said, look, if you're really arguing liberty, which means you really should be arguing due process. We rejected this from day one. We said, no, federalism, the structures, the limits on the federal power is a protection of liberty. It's the original protection of liberty. There was no Bill of Rights for 2 years. There were only the structural protections of the Constitution. And not only did we make that argument from day one, but I think it really influenced the outcome of this case. It's the reason why Justice Kennedy was such a firm vote for us, because he, in the Bond case, and now in this case, in the Bond case he telegraphed his view, but he didn't need to, and in this case he strongly reaffirmed his commitment to the idea that the structural constraints of the federal government are protections of liberty. They are the original protections of liberty, and if we disregard them because we want to achieve some particular public policy like national health care, then we are going to be undermining liberty. So, Jim, I think you're absolutely right. And I also think we wouldn't have gotten 5 votes in this case if this case hadn't been framed this way and that framing hadn't been accepted by 5 justices.
All right, next question.
Kai Alberg, Port Angeles, Washington. Last week, a number of states passed or had on their ballot various initiatives to block the implementation of Obamacare in their respective states. I'd like the comments from the panel as to what you believe is the effectiveness of those state-by-state measures, and also whether you believe that the states under Article 1, Section 10 can form interstate compacts that, with approval just from Congress, without approval of the President, could take those states out of a legislation such as the Affordable Care Act.
All right, who wants to take that one on? Yes.
So, I mean, I think it's one of the most interesting parts of the way the healthcare law has been implemented. I mean, you even sort of see divisions within the states where the executive is saying that he's against having it, and meanwhile the administrators are busily creating the infrastructure to have it. But we've seen this before. This is exactly what uncooperative federalism is. And in some ways, this is, I think, why the question is for the states, do you want to be in or do you want to be out? Because if you're completely outside, imagine we had a world where every state was had just an easy choice, in or out of the healthcare implementation. If it's out, is not just that the federal government will go ahead and implement it for them. It's that you actually won't have the people who are most likely to oppose and resist the law inside the system. So this is in some ways the funny perverse consequence of the commandeering rule. So the commandeering rule has one benefit, which is that it creates conditions of bargaining that give the states some leverage when they're negotiating with Congress over what they're going to do. But on the other hand, the commandeering rule also lets all the people who don't like the law to step outside. And you should just ask yourself, do you want a system where the people who are most skeptical about the policy are on the outside with no influence whatsoever over what's going on? The people with influence are the ones who are inside. And they have influence because the federal government depends on them once the infrastructure is created. They have influence because they talk the same talk. They know how to speak to the bureaucrats in a way because they're insiders and therefore have standing in the sort of colloquial sense. They know a lot more. I mean, one of the things that you learn about ad law is that all the groups on the outside who are trying to figure out what's going on inside don't have nearly as much influence as reformers within the system, because the reformers within the system have the facts that they need. So I think it's a really interesting question what the states are going to do going forward, particularly the ones who are in opposition to it. I actually think it's healthy. We all have our views on how much rebellion is appropriate, but I think it's useful for the federal government, when it's implementing this policy, to recognize that there's a significant proportion of the country who's against it or who has doubts about the way it's being implemented. And it's only by having those actors inside the system that the federal government's really going to feel the sting of it. Otherwise, they can just do what every majority does, which is called radio silence. Don't engage with the dissenters if they're on the outside. That's the easiest thing to do. But if they're on the inside, they have to engage with them.
All right, next question over on this side of the room.
I enjoy, Gerald Walpin, I enjoyed the fact that a couple of the panelists, especially Professor Gerken, lectured us on the fact that judicial restraint involves the element of deference to legislative decisions. And most of the discussion was in the Commerce Clause field, where there isn't the black and white clear area of precedent and what was intended at the beginning when the Constitution was written. I wonder if we could ask Professor Gerken to apply that to the cruel and unusual punishment provision, which certainly was understood at the time that the Constitution was adopted and the Bill of Rights were adopted, to include death penalty, life sentence for recidivism, and other statutes which were adopted by almost every death penalty and such statutes adopted by every state legislature and approved by popular opinion in every poll.
Counsel, I'm going to have to interrupt in the interest of time. I think we have the question. It's judicial restraint and the Eighth Amendment. Professor Gerken.
So I'll actually just say I wasn't the one. It was actually Neil Katyal who was talking about deference to the popular branches. So I feel like I'm stealing his.
Those liberals are all the same.
Yeah, right, exactly. But it's very easy to confuse the two of us. We look a lot alike, and but and the other thing I'll just say is my views on this are not originalists. I'm not an originalist. I am not of your tribe, and so I think my answer is likely to be completely unsatisfactory to you because it won't be cast in the terms that you're casting it. But I'm happy to let Neil jump in since it's his
Well,
baby.
and this discussion may be beyond the scope of the topic here today, so I think we'll have to leave it there and take another question here from the center and maybe one more before we have to recess.
My question is to Professor Gerken. I believe you indicated that whether or not a certain aspect of federalism should be accepted should be based on the effect it has on minorities and certain other groups. I'm wondering if you can think of another country in the last 100 years, anywhere in the world, that has been as deferential, almost obsequious, to minorities as America has. And the second part of the question is, do you think that the effect that a law has on a certain group of persons in our country should determine whether or not it's constitutional?
So I'll just say two quick things. First, I'm going to do what I tell my law students never to do, which is resist the hypothetical. I'm not going to, I don't agree with the premise of it, so I'll just say very simply, when we think about decentralization, there are a variety of functional considerations that we think about when we decide whether to move up or down the ladder, up to the national, down to the state, down to the local. And on that pile of functional considerations, I want to insist that thinking about race and descent is something that matters. And I would like to just say that if you want to convince the progressives of the value of decentralization, you have to be able to come up with an answer to that question. I am the rare progressive who actually thinks that decentralization has real value for racial minorities and dissenters, and that in thinking about the functional policy consideration of where to move power up and down, I do believe it's entirely appropriate to put that on the scale. How you balance the scale in any given instance may be different, but in deciding the question of where power should lie, I think that is a legitimate consideration, especially given our own history.
All right, on this side of the room.
Bonnie Wachtel. Well, I'm sorry Mr. Nadelson left, and please tell him if you see him that there was at least one person in the audience that was entirely captivated by his novel idea and wanted to...
He had a plane to catch.
Okay, well, if that's an excuse. So out of frustration with that, I'll ask a rather frustrated, petulant question to Randy Barnett, which is, exactly what is all this withering pressure that one can apply to a Supreme Court justice? You know, I just find it unfathomable that John Roberts wanted to be part of the in crowd with the New York Times, that sort of thing. It makes me think he actually did believe in the decision that he wrote. But just to stand back and look at it from a cultural, sociological, psychological, whatever is meant to amplify that comment, could you give us a little more color on what happened?
What was the last, can I give you, I didn't hear the last part of that question.
Little
Color,
more
can I give you
comment
more
on
color?
that
That seems like the previous question. The pressure, it's subjective. It depends on who you care about. It depends on who your audience is. It depends on who you think is going to make your legacy. We all have our pecking order in our life that we live by. You know, we have the people that we look up to. We have the people we don't look up to. We have the people whose approval we want and the people whose approval we don't care that much about. This is just the way we all are. So I don't think the Chief Justice is any different in this regard than anyone else is. As to whether he really believed the decision he made, I don't know what was in his mind, and I'm going to assume that he did believe it, but I think that if reporting is to be credited, he didn't believe it during the conference after the oral argument. This argument that was so persuasive was an argument he came to be persuaded of some 5 or 6 weeks later. So we'll assume that these are his sincerely held beliefs at the time he wrote his opinion and he uttered it, but it wasn't such a compelling argument that it either had occurred to any other judge who was deciding this case, any other justice who did decide this case, or even he himself on the Friday after oral argument was held. So it's only an argument that became persuasive later on, and at that point I think we're allowed to ask ourselves whether really an untoward publicity campaign of disdain, which was, and I have a piece coming out in the Harvard Law Review Forum about this, a campaign of disdain that was leveled at the court after the case was submitted. When I was a prosecutor, speaking of being a prosecutor, when I was a prosecutor in Chicago, once we had a case that went to the jury, as much pressure as there was to prosecute that case, the least thing, at that point, once the case went to the jury, we got to go back to our office and look at our other files. First we went out to have a drink, and then after that we went back to our office, we looked at our files, and we could go work on other matters until the jury came back, because nobody could talk to the jury while the jury was out. So once this case was submitted, I think what was the appropriate thing was for all sides to go to their neutral corners and wait for the court to decide. It's not what the supporters of this law did, starting with the President of the United States on the Monday following the oral argument, proceeding through every single columnist and opinion pundit on the left, culminating in the Senate Judiciary Committee Chairman Patrick Leahy's speech from the floor, in which he urged the justices to do X, Y, and Z after the case was submitted. This was wrong. This was wrong. This was bad conduct. Some of us had to rise up midway through that process and try to defend the court from this onslaught that was being leveled against it. But it's something that should never have happened and would have tainted any decision even that upheld the act, even if there had not been a switch in votes. because there would have been always the speculation that there had been a switch in votes. We wouldn't have needed we wouldn't have had the benefit of the reporting. So this was all wrong. And whether it did or did not have an effect, it certainly gives the appearance of having had an effect. And I think that, I just think that it's something to be regretted. And I think when we vet future judges to be on the courts, we have to be concerned not only with what their beliefs are, but whether they're willing to stand by those beliefs when the chips are down, given the fact that they have lifetime tenure for that purpose.
Last question, Professor.
Yeah, I'll try to make this quick because I know I'm holding up people on the way to the exit. So several of the panelists seem to have endorsed this proposition that there's sort of been a big shift away from the original philosophy of the Federalist Society to being opposed to judicial restraint. And obviously there's a long and complex history here, but I wonder if one of the reasons why the Federalist Society was called the Federalist Society in the first place was because the people who founded it thought that the federal government had overreached the constitutional bounds of its power, and maybe therefore something should be done about that. Also, if you look at conservative jurists like then later Chief Justice Rehnquist, and what they wrote about these issues in the 70s and 80s, they wrote things like his opinion in the National League of Cities decision in 1976, or several other cases that could be cited. So I wonder if there's more continuity here than some of the panelists have suggested. Not that there has been perfect, complete consistency over time, but I think one of the themes of both the Federalist Society and also conservative jurisprudence more generally, beginning with the 70s and 80s, was precisely that the federal government had overreached the bounds of its power, and that judicial review, as Rehnquist consistently advocated in the 70s, is one of the tools that need to be used to rein it back. So they were worried about judicial restraint as well, but restraint in the sense of sticking to the meaning of the Constitution rather in the sense of just deferring to the legislature and letting them do what they want.
All right, that was really more in the nature of a professorial comment, which I will give you license to do. But if there's any comment, please feel free. Anybody?
It's a fitting note on which to conclude.
And I think we will. The lunch is served in the rooms across the hall.